This is just a very basic outline on like what you need to know, possibly pre-escrow, pre-sale, and also some of the pitfalls. So it's sort of like escrow. It's like probate escrow 101. Anyway, so during the escrow, let's go to the first one here. Yeah. So pre-escrow, let's start there. I like to order everything up front because we hate having surprises. I do this actually in my regular resale practice as well, but it's critical to order everything, especially on something that is a court-ordered sale up front, because all these things need to be, there can't be any contingencies when you petition the court for a hearing date. So we do get a prelim, any city reports like a 9A. If you're in LA City, in Thousand Oaks, it would be the equivalent of the Thousand Oaks Building and Safety Report. NHD, homeowners docs, especially out in your valley, like every other property is an HOA, NHD. And then if we have the ability to review that prelim either with the agent or even the attorney, we're going to have requirements. So when someone's deceased, one of the big ones is that we will always need a tax ID number for the decedent, which always needs to be applied for far ahead of time, even if it's a decedent's trust. If you're just selling, which is a very common sale, if you're selling someone's home and the last to die, and it's the children selling it, for example, and mom was the last to die, we need to file everything under a tax ID number, not a social security number. Okay. Some of the critical points in reviewing the prelim. One is, especially if it's court ordered, make sure that the names of the sellers match actually identically what's on the petition. I actually ask the attorneys to send me a copy of the petition and the service list so I can check certain details that are very basic, really basic, but will hold up a closing if they are wrong on the order, such as the name of the vested owner or trust and date name, the legal description, the assessor's parcel number, checking for other deceased co-owners. Very common problem. There could be two people on title. If they're joint tenants, it's great because we can just do an affidavit of death of joint tenant. But if they're not, it can get very complicated. And that might be something that, you know, somebody forgot to open a probate for someone long deceased. So we like to get all that reviewed early on and make sure there's no issues. If title's held in a trust, we like to verify if there were any changes made to the trustees. Sometimes those are recorded. Sometimes attorneys prepare those and they get recorded for the clients if they're smart enough to seek counsel. And sometimes they aren't of record. So we need to know that because we need to know who the final signer will be. If there's changes, again, are they recorded and are they properly hitting this property? The main issues, again, in comparing, for example, a court order, so there's many types of probate transactions, including a decedent's trust sale. We kind of put that in that category as a probate because there's many exemptions on a decedent's trust. But for example, on Independent Administration of Estates Act, which does not always require court confirmation, it does sometimes. We don't necessarily go through all these steps because we can make all the adjustments while we're in escrow, but it's very prudent to do all these things in advance of opening an escrow. So again, you want to make sure the legal description is correct. Are there any loans or liens of record that need to be removed? So recently I had a transaction that had 12 bail bonds recorded against it over like 20-year period. A lot of those companies went out of business. We needed to get, we need releases on all of them. And the ones that we couldn't reach or couldn't get releases on, we had to actually go to a bonding company to bond around it. And these things just take a lot of time, or we'll find really old deeds of trust of record that that we can't locate the parties. Those need to be bonded around. Bonding does take time. We also verify all our information on these orders by using a tax roll that we get directly from the title company. So we are really verifying the information is correct. I know everybody knows we're in the middle of tax season right now. So all the tax rolls have been updated for the 2021-22 tax season. On a trust during escrow, if For example, a successor or interim trustee is appointed by the court, we need to have all those entity docs. For example, when that applies, if it's a professional fiduciary, and there are many fiduciaries in our provisors groups, but if it's a professional fiduciary, for example, you know, they aren't always going to show of record on our title search. So we need to provide that information. And often this is done by court order. The usual reason why a professional is hired is because there's either elder abuse involved, or the family doesn't get along, or the siblings can't work it out. I mean, there's just a litany of reasons why they do that. Or it's a huge estate, and often it's just overwhelming to be handled by an individual instead of a professional. And there are many in our groups that do all kinds of fiduciary work. I'm happy to give referrals if anybody finds out that they need something like that. One of the biggest issues we have, we find time and again, and this is resale or in probate, is returning escrow documents very quickly. Makes the process so much easier. So for example, when we're not getting a seller package back right away, we have no idea what the possible nuances are, if there's mistakes in the package, if there's a notary problem. Often we're dealing with clients that are out of state or out of area. We happen to own a national signing service, but it's helpful in that we can locate a notary, but the notaries don't give advice. Even our local notaries don't. But they can't give advice on how to complete the packages. And often individuals struggle with this. I had a call this morning from someone that was a successor trustee and had a lot of the information on his package either not completed or wrong. And he kept saying, well, the notary didn't explain to me how to do it. Notaries are there just to verify your signature and notarize your documents. The clients need to call in and get help or support, usually from escrow or their attorney if there is one. And that is critical. The delay in packages will ultimately delay the close of escrow, especially if there's a problem. Communicating us with escrow periodically during the process is critical, and making sure that everybody is on point and people have turned things in, because I think a lot of times properties are put in escrow and the clients don't realize their clients aren't performing. We do regular reviews and we try to alert people, and we'll send out DocuSigns a second time, copying an agent or an attorney. But we need expectations managed before they get into escrow, telling them when you receive communication from your escrow people, it's absolutely critical that you respond. This does not happen on like 85% of our transactions, and we find that we're chasing paperwork, which is a real deterrent to getting deals done. People that turn in packages early enough, we are working on those deals to move them toward a close, and we can't work on deals that don't have paperwork. So it's just kind of a sticking point across the board, especially in probate work. Post escrow. This is key, and I see that attorneys don't even make this recommendation to their clients. Absolutely always tell the seller, whoever they are and in whatever capacity they are, to withhold money and not to release absolutely every dime of the proceeds on any kind of a transaction, including a decedent's trust sale. There are so many expenses post-close that come up that the person responsible, and it's usually one person, and then that person, the successor trustee, the administrator, the executor, the conservator, whoever they are, those people are the ones that are responsible to get those bills paid. I had a transaction last year and there were 10 beneficiaries and there was attorneys involved, and it was not for a parent, but for a relative, like an aunt. And so they got hit with a like $9,000 tax bill, and he said, what do I do with this? And I said, you're going to have to pay it. And he said, I've already distributed the money, and there were 10 beneficiaries. So it's the little details that make such a difference for your clients and those communications and managing their expectations. All you had to say was, like, I handled my dad's trust when he passed away. It was not a big estate, so I only held $10,000. But most transactions we see, even if it's a $750,000 transaction, I would withhold a minimum of $25,000 just to make it happen. and to make sure that anything coming in post-close up to a year after the closing, because you have to file, even like on a decedent's trust, which is a very common transaction, you still have to file a closing tax return. Somebody's got to pay the CPA. So those are really key, really important things to really alert your client of. A lot of times these sellers don't ask us, or we will share that information because we're not really knowing what they're told or not told by their counsel. When I have a decedent's trust and I see that the property was never taken out of mom or dad's names, I will go the extra mile to try and give some guidance through this. But of course, escrow companies and escrow agents are not able to give per se advice. I can give some guidance. I don't really tell people they need to hold money. I'm just sharing that that's my experience and that's what I did because I see these bills come in regularly, and people, the successor trustees will email me and say, why didn't you pay this through escrow? And I'll say, did you talk to your attorney? Was a parent to child transfer form filed as soon as mom or dad died? And in really all cases, that never happened. So children of parents that pass away assume this is all handled. And I see this time and again, like every month in my practice. And they don't understand that there are things that must get done to report a death of a family member. And so we like to make sure that if the agents are educated and the attorneys realize that their clients don't understand this, that, you know, these things are cleared up well before they're in the escrow process. And just a couple of quick notes on some of the big pain points that we see. Proper disclosures by agents on physical aspects of the property, including number of units, the type of property, status of tenant occupancy, leasing, zoning, and lot size. Some of these are just not addressed, and people will often come to escrow, which this is not something we can help them with. And we have to refer them back to the agent. We have to refer them to their agent, and they're going to have to go back to the listing side, make sure all these things are really disclosed properly. If there's any hiccups with the property, this is the time to do it before a client signs off on it. Remember, these kind of deals, including for the most part a trust sale where, you know, the successor trustee does not live on the property, these are as is where is sales. I mean, they truly are. There's no disclosures really that somebody who's deceased or incapacitated can make. So it's critical that the agent representing the owners of these types of properties understand all aspects of what can come up during the process and how critical it is to disclose any little thing. We often find, based on price points, that some properties are damaged, or, you know, somebody homeless moves in during the escrow period. These are all things that need to get addressed with the buyer prior to closing. So, you know, there's no issues taking over the property. Additionally, I know I personally hate surprises, but nobody likes a surprise when they're in escrow. I mentioned in the first slide how important it is to really please open these prelims and take a peek at it. And if there's something you don't understand, just let us know, you know, or let your title officer know. And on a court confirmed sale, last but not least, absolutely critical to have the absolute final vesting. It goes right onto the probate contract, but it has to be given to the attorney. So if somebody's unmarried, married as their sole and separate property, a trust, an entity, all these things need to be on the court order. The escrow company on entities, such as an LLC, needs all the entity docs. For those of you that haven't come across it, title companies have to do underwriting called FinCEN. We need tax ID numbers. This stuff, you need to make sure that the person who's signing the contract is the proper signer. You won't know that if you don't get entity docs. So those are really critical pieces.